Good afternoon. My name is Anne Sedey. I'm a lawyer here in St. Louis. I practice employment law, and so on the employee side. And so I think it's just fitting that I'm moderating this panel, which is about how we use the courts and the law in the fight for equality over the last 45 years. It's going to be a really interesting panel, I think, because we're going to start with two historians who have looked at these questions from a really broad historical perspective, and then we're going to talk with two sort of on-the-ground practitioners who've worked in this area of law in St. Louis for the last 30 to 40 years. So we're going to hear the broad overview from people who have really looked at it at that level, and then just kind of what it was like to be on the ground fighting those individual fights. So we're going to start today with Katie Turk. Katie is an assistant professor in the Department of History at the University of North Carolina at Chapel Hill. Her research focuses on post-war American feminism and its relationship to political and legal struggles for workplace rights. She is working on her first book, which will be published soon, called Equality on Trial: Sex and Gender at Work in the Age of Title VII. And she's going to talk to us about the interpretation of Title VII, how Title VII's focus was narrowed, and what the sort of outcomes of that were for all of us. Katie?
Well, good afternoon. It's a great privilege and also somewhat intimidating to follow Alice Kessler-Harris, sort of the grand master of our field of working women's history. But I'm delighted to join all of you today as we celebrate, take stock of, and critically engage with feminist workplace rights activism of the present and the recent past. This is an especially timely and significant project today, because as Professor Kessler-Harris sort of mentioned a few minutes ago, we're constantly confronted with such mixed messages about women and work. On the one hand, we hear that workplace sex equality has mostly been achieved, that sex bias has been written out of the law and out of corporate structures, and that the rules of the game are essentially fair. Adopting this perspective is Sheryl Sandberg's recent self-help book, Lean In, perhaps infamous among our circles, which conveys that in order to advance at work, women need only cultivate new methods to advocate more strongly for themselves. Yet we're also bombarded at the same time with messages about stubborn sex-based inequalities, from differential pay scales, widespread sexual harassment and pregnancy discrimination, to the failure of the federal courts as a route to sex-based economic justice, demonstrated most recently by the Walmart class action defeat in the Supreme Court in 2011. So as a historian, my instinct is to examine the past as a guide to help us unpack this paradox. And my hope is that by looking backward, that is, by excavating and tracing past struggles and strategies, we can shed some new light upon our present moment and bring into view a different set of possibilities for the future. As Marianne mentioned, my research is mostly about women's campaigns to enact Title VII of the Civil Rights Act of 1964, which you'll hear a lot about in our panel. Title VII was the first federal law to ban sex discrimination in employment. The world of work in the days before Title VII would look unfamiliar to many women just coming of age today. In 1964, the year Title VII was passed, the three most common occupations for women were secretary, sales clerk, and office machine operator. In most American workplaces, men held positions with significant authority, higher pay, and autonomy, and they used their power to relegate women to supportive roles. This gendered division of labor was underscored by an elaborate system of laws in all 50 states that regulated women's working conditions, pay, hours of labor, and more, these protective labor laws we've heard a lot about already. It was also reflected in popular culture through stereotypical figures like the Girl Friday, the dedicated and plucky office helpmeet who was indispensable to her boss, but whose accumulated wisdom would never embolden her to make a play for his job. This labor force segmentation gave weight to a gendered worldview that framed men as inherently decisive and authoritative, and women, by contrast, as naturally passive and adept at following directions. In the mid-1960s, new federal sex equality laws like Title VII gave women, and some men, new ways to chip away at this naturalized regime of gender difference. Prior to Title VII, most workplaces were sites where sex differences were upheld and legitimated. But after Title VII's passage, these same workplaces became sites where bold ideas of sex equality were tested. And in this process, the very meaning of sex and gender difference in American life was sort of contested and remade. So my book really argues that Title VII opened a new vital chapter in a longer struggle to define the proper relationship among working women, employers, and the state. Title VII's passage created a groundswell of energy from aggrieved workers and activists who encountered attorneys and government officials to debate the power and promise of state-enforced sex equality. What would this new right to sex equality at work actually mean in practice? But engaging in the politics of sex equality in order to reap Title VII's new benefits also created new and unforeseen challenges. My research shows how government agencies reframed and rationalized the broad range of workers' demands in pursuit of administrative efficiency. Attorneys, some of whom we'll hear from on this panel, worked within existing legal channels to accommodate workers' demands, but also to build viable cases that they could win based upon legal precedents. Feminist groups struggled in some ways to articulate and actualize a workplace rights agenda that would work for all women, that could speak for all women. Labor unions faced systematic external challenges that I'll talk a little more about as they worked to accommodate their various constituencies. At the same time, massive national corporations and small employers alike fought to oppose or limit some of the changes workers sought, right, trying to contain some of these rights claims, and oftentimes finding ways to reorganize and further de-skill feminized jobs in pursuit of profitability. And finally, we see conservative government actors who began to build political capital by framing expansive forms of sex equality as assaults on male breadwinners' prerogatives at home and in the workplace. So the sex equality laws of the 1960s, primarily Title VII, created unprecedented new opportunities for laboring women, but they also presented new challenges. And in the brief time that I have today, I want to just talk about one sort of case study, one strand of this working women's movement in the wake of Title VII, and that's the movement for comparable worth. And I want to use that example to demonstrate both the vitality of women's efforts to engage Title VII, as well as the complexity and power of the forces that oppose them, to try to think about the potential, but also the limits of legal strategies in women's campaigns for workplace justice in the aftermath of Title VII. So in the early 1970s, about a half a decade after Title VII is passed, a coalition of labor and feminist groups began to argue that Title VII's promise of workplace sex equality should apply to pay practices. They argued that women's wages were artificially depressed because they remained clustered in a handful of low-paid occupations. And they began to argue that creating meaningful sex equality required more than just moving women into work typically performed by men. Instead, they demanded an expanded interpretation of sex equality law, what they called equal pay for work of comparable worth to the employer, or what they also termed pay equity. So I'll sort of use comparable worth and pay equity interchangeably. They meant the same thing. Comparable worth advocates claimed that the statistical difference between women's and men's average wages, which for decades had hovered around 40%, was a vestige of the family wage ideology, something Professor Kessler-Harris spoke about earlier. And this was just simply the notion that a worker's pay should reflect his or her presumed status as a male provider or a female dependent. In the era of state-enforced sex equality, these comparable worth advocates argued, the wage structures workers had inherited from earlier times reflected the systematic devaluation of feminized work, rather than the value-neutral output of an impartial labor market. Comparable worth allies had initially had sort of powerful friends in federal government circles starting in the early 1960s, as Bridget O'Farrell mentioned earlier, when President John F. Kennedy and also the President's Commission on the Status of Women advocated for a comparable worth standard in the draft Equal Pay Act. But for various reasons, the compromise version of the bill that was passed in 1963 contained a narrower standard. The Equal Pay Act of 1963 simply requires equal pay for substantially equal rather than comparable work. So starting in the mid-1970s, advocates began to frame comparable worth as a class issue and as a labor movement issue. Simply helping women to obtain male-dominated jobs was just not enough, they reasoned, because someone, after all, would stay behind in the female-typed jobs that some talented women would leave behind. And those women, those workers in those jobs also deserved to be paid fairly for their work. AFSCME, the American Federation of State, County, and Municipal Employees, became the nation's most forceful advocate for comparable worth as that union entered a period of dramatic growth and feminization in the early 1970s. AFSCME reached 1 million members in 1978, and the union bargained from a position of increasing strength, compounding its size and clout and winning new contracts in schools, libraries, hospitals, and offices, places that were heavily feminized in their labor force. AFSCME began to build a robust women's rights campaign that opened leadership positions to women and took their concerns seriously, ultimately writing women's concerns into many of their sort of mission statements and labor contracts. And AFSCME, by the mid-1970s, comes to settle on comparable worth as the centerpiece of its campaign for workplace justice for women. AFSCME's comparable worth strategy also included building partnerships. AFSCME was a founding member of the National Coalition for Pay Equity, the first national group dedicated to the sort of pay equity struggle, formed in 1979 to serve as a clearinghouse and action center for activists fighting to upgrade the jobs and the wages of women workers. Women's labor advocates joined the comparable worth struggle as well. Of course, the Coalition of Labor Union Women, or CLUE, founded in Chicago in 1974 to address what they called, quote, special concerns as unionists and as women in the labor force to join together an inter-union framework. By the late 1970s, CLUE had 7,000 members and was at the forefront of advocating for federal protections for comparable worth. Feminist social movement groups also publicly committed themselves to the comparable worth struggle. Now Action Vice President Mary Jean Collins, sitting right here, urged the group to put its full support behind pay equity, both as a matter of justice, but also as a social movement building tool. Collins wrote, quote, most women know there's something wrong with their paychecks. And if we frame the issue properly, we have unlimited possibilities for state and local actions involving public and private employers, and for legislative and public information activities. How'd I do, Mary Jean? Okay, she did say that. Okay, so by the late 1970s, as Professor Kessler-Harris sort of indicated earlier, there is this feminization of some of the major unions in our economy, in part because of the changing labor force, but also because women are coming together and sort of demanding this from within their unions. And so by the late 70s, you have this robust coalition of labor and feminist groups who come to identify comparable worth or pay equity as the key plank of their economic justice agenda. And they increasingly focused on the state, in particular, Title VII's ban on workplace sex discrimination as the muscle that could force employers to remake their pay practices along comparable worth lines. At first, this proved to be a very sound strategy. The federal judges and officials that this coalition encountered often shared their view that comparable worth was already within the scope of sex equality law as it already existed. In 1981, the U.S. Supreme Court ruled that a group of female prison guards could pursue equal wages to their male peers, even if the substance of their work was not identical. 2 years later, a federal court in the state of Washington ordered the state government to implement comparable worth wage adjustments worth millions of dollars on behalf of female state employees. Emboldened by these early victories, AFSCME officials and their coalition partners launched a nationwide effort to use Title VII to turn comparable worth into reality, filing local, state, and federal charges with government agencies and also in court. As of 1982, AFSCME had the most active litigation program of any union in the country, and this effort was focused squarely upon the fight for comparable worth. So comparable worth wage adjustments are sort of the social movement goal, and they focus on the law as the muscle to bring this about. The union and its allies believed that they were laying the groundwork for a U.S. Supreme Court decision that affirmed comparable worth as an essential element of state-enforced sex equality once and for all. But as courts wrestled with comparable worth and labor and feminist groups coalesced to fight for it, officials in government agencies who were sort of tasked with interpreting sex equality laws came to embrace it outright. And many of these characters will sound familiar to you. Key among them was Eleanor Holmes Norton, EEOC chairperson from 1977 to 1981. Upon assuming her chairmanship of the EEOC, she began a deliberate campaign to enshrine comparable worth into national policy. But she realized that making the theory a permanent part of Title VII law would take time and care. Over several years, Norton took patient steps towards building public support and a legal foundation for comparable worth, surveying legal options and scholarly research, and coordinating public hearings on the issue. Momentum was building at the grassroots, too. In 1983, pay equity campaigns were unfolding in more than 140 cities, states, and local areas, and they're increasingly focused on the law as the way to bring this about. But as comparable worth advocates began to coalesce and push for definitive victories in federal court and enforcement agencies, this deliberateness also gives its opponents time to sort of catch up and fight back. A group of corporate leaders called the Equal Employment Advisory Council, close to the EEOC, but they're the EEAC, and they're much different, formed in 1969 as a privately financed lobby group, pledged to mount what they called a legal counterattack on Title VII by drafting and feeding proposed labor legislation to conservative members of Congress. In the mid-1970s, as they sort of see comparable worth gaining momentum and think about what it might mean to be forced to remake their pay practices at the ground level, moving up, they also come to focus on comparable worth as policy that they want to limit or even strike down. Business interests coalesce in order to block comparable worth at the local level as well, accusing pay equity advocates of violating sacred market principles, an argument that we still hear, and pushing the law of sex equality beyond its intended meaning. So arguing that sex equality in the workplace is not about actually remaking pay practices to reflect value created. It's simply about removing barriers, right? The liberal feminism that Dr. Kessler-Harris mentioned a few minutes ago. In addition to these sort of external conservative opponents in the business community, by the mid-1980s, many key comparable worth advocates in government positions, like some of the progressive judges and Eleanor Holmes Norton, had been replaced by its opponents. And these conservatives broke the back of activist government-oriented strategy. 1985 saw the U.S. Commission on Civil Rights, the Equal Employment Opportunity Commission, and federal courts issue resounding condemnations of comparable worth. In an oft-cited comment, Civil Rights Commission Chairman Clarence Pendleton described comparable worth as, quote, the looniest idea since Looney Tunes, which was then a children's cartoon. At the EEOC, Eleanor Holmes Norton had been replaced by conservative jurist Clarence Thomas. Yes. Thomas, at this point, was well known already as an outspoken opponent of comparable worth, and even earlier gains began to slip away. In 1985, the Ninth Circuit Court of Appeals reversed the earlier lower court ruling, rejecting comparable worth in the state of Washington as a grounds for a Title VII sex discrimination complaint. The next year, the Seventh Circuit Court of Appeals threw out a similar case on behalf of nurses in Illinois. That court's en banc ruling described comparable worth as, quote, not a legal concept, but a shorthand expression for the movement to raise the ratio of wages in traditionally women's jobs to wages in traditionally men's jobs. So advocates find in the comparable worth struggle that the law has incredible potential to deliver improvements to working women, many of which we heard in the lunchtime talk. But those improvements or that potential could just as easily disappear, right, if the key advocates in the legal bureaucracy were replaced by folks who are opponents of these policies. So to channel Title VII's breathtaking power to transform workplace policies and punish violators, comparable worth advocates had put the bulk of their resources towards litigation. As they built their campaign, they were encouraged by early victories in the legal arena to continue to frame comparable worth as an issue of national public policy. Yet, they were working to expand Title VII's interpretive boundaries just as business leaders and conservative officials sought to retract them. Advocates had framed comparable worth as a problem to be solved through legal channels and built up the methods to pursue it. But those mechanisms and definitions could not be easily retrofitted once conservative officials closed that avenue to them. Once these federal officials sort of withdrew Title VII's muscle as a potential weapon in the fight against systemic pay discrimination, activists after the mid-1980s were left to make their case in a much less powerful way, limited to campaigns in a few sort of local public sector workplaces and state by state, as opposed to the federal level. So through the lens of the pay equity struggle, the 1980s appears not as a decade of steady backsliding for the left, but as a testing ground for feminists' most radical efforts to use Title VII to remake American labor practices. Pay equity's demise at the national level at the end of the decade was not the result of a consistent mainstream consensus that it was too radical, but in some ways of poor timing. Its advocates in the government and labor and feminist movements never quite synced up their power when they were at full strength. When feminists and some federal officials advocated it in the 1960s, it was not quite yet among union leaders' top priorities. In the 1970s, comparable worth was peripheral to many feminist social movement groups' agendas, even as its advocates in the labor movement and the federal bureaucracy sort of slowly and deliberately built the groundwork for its adoption in equal employment law through supportive legal precedents and careful study. This deliberateness also gave pro-business opponents time to muster a powerful counter-movement, and President Ronald Reagan replaced formerly sympathetic bureaucrats with hardcore social conservatives who pronounced comparable worth to be beyond the scope of sex equality law just a few years later. So, at the heart of the debate over comparable worth and Title VII was a disagreement about the nature of sex discrimination, whether it was a systemic phenomenon produced by biased systems or an interpersonal issue perpetuated by individuals. And we see in the mid-1980s courts and federal officials ultimately choosing the latter, and therefore the push for comparable worth in some ways does outlive its legal potential. Great grassroots activism continues after the federal court losses, but without federal endorsement, activists sort of have to fall back on the tactics of more local activism and persuasion. So Title VII delivers incredible victories to working women, many of which Professor Kessler-Harris spoke about and will continue to hear about on this panel, but in some ways pushing for big changes at the federal level that it promises can have unintended consequences if the key actors that you need in place are not quite there anymore. By the late 1980s, courts and federal civil rights agencies had diminished Title VII's potential as a bulwark against the intersectional sex, race, and class disadvantages faced by those women who were unable to advance in the workplace as individuals, right? Those women who Sheryl Sandberg can't quite reach with her message of just trying harder for yourself. And therefore sort of buttressing conservative arguments that the labor market was a sex-neutral system whose unequal outcomes reflected individual choices and the intrinsic value of work. In the end, the lack of a comparable worth moment of convergence has meant that the low wages that were once justified by sex-based arguments could spread across the service sector. And while the wage gap between working men and women has narrowed, we've seen it stubbornly persist, and it still persists today. But I don't want to end on such a sort of downer note, because thankfully we have so much feminist energy and potential here with us. We've learned about wonderful historical examples and we'll continue our sort of brainstorming session as we move forward. Unfortunately for us, we do not need to look too far back into the past to find strategies that we can test and sort of cull from, heroes and heroines who will inspire us, and a robust vision of industrial democracy that puts working women's needs at its center. So, thank you.
Thank you, Katie. That was really wonderful. Our next speaker is another historian, Mary Ziegler, who actually is technically a legal historian, I think. Mary has devoted her career to studying reproductive rights issues. Her book, The Lost History of the Abortion Debate, will be published by Harvard University Press next spring. She has been on the faculty of the law school at St. Louis University. She's currently on the faculty of the law school at Florida State University. And she's going to talk to us today about the specific subject of Title VII and pregnancy and how that subset of issues under Title VII came down, developed over the last 30 or 40 years. Thank you.
So as you gathered, I'm going to talk about two types of work, reproductive work and employment. Sorry, I'm too short even with high heels. So this project really emerged out of my book, which began itself when I was in law school. And I noticed how often everyone talked about how social movements and feminists reacted to Roe v. Wade. The Supreme Court talks about it in deciding whether Roe should be overruled or modified. Historians and legal scholars talk about it in determining what the best method of constitutional or legal interpretation should be. Historians and sociologists talk about it in describing the defining traits of movements for or against reproductive rights. So I looked for the book that described this history, and it didn't exist. So I decided it would be good if I tried to write that book. And the journey took me to over 16 archives, led me to interview over 50 people who were involved in the struggle for or against abortion rights in the decade after Roe. And what I found generally is that we've put too much responsibility or blame on the Supreme Court, and that a lot of the polarization and kind of hopeless circularity that we now associate with the debate came later and for reasons largely beyond the Roe decision. And part of that meant that there was a world of abortion politics in the 70s that little resembled the one we know now, a world in which certain kinds of narrow and seemingly now bizarre compromises existed between women on opposing sides of the abortion issue, at least when it came to equality at work. And those compromises involved a much maligned idea of choice. All of you know that most feminist commentators, from Ruth Bader Ginsburg to Catherine McKinnon, have argued that choice is a bad way of framing abortion rights, because choice implies that getting pregnant or not is something women can simply volunteer to do, and that by definition, social justice doesn't come into the picture. We don't need state assistance. We can simply choose not to be pregnant whenever we want. In the 70s, though, there was a kind of transformative idea of choice circulating in many feminist movements, the idea that choice meant nothing if you didn't have the means to effectuate your choice. That could mean maternity or paternity leave, it could mean safe and affordable childcare, and at a minimum, it had to mean protection from discrimination against discrimination in the workplace. Now, this idea was articulated by feminist litigators in a variety of cases, litigators including Wendy Webster Williams, Ruth Bader Ginsburg, and Jane Picker, who litigated the Cleveland Board of Education versus LaFleur case. It appeared in litigation involving both Title VII, in the sense that feminists argued that pregnancy discrimination had to be sex discrimination, and it appeared in litigation involving abortion rights, when feminists argued that the right to choose had to involve access to funding in public facilities. Now, these arguments famously failed in the Supreme Court. In a brilliant decision, Geduldig versus Aiello, the Supreme Court held that under the Equal Protection Clause of the 14th Amendment, pregnancy discrimination was not sex discrimination because, after all, men routinely became pregnant. In 1977, the Supreme Court followed that up with another wonder of reasoning, Maher versus Roe, which held that at most the right to privacy involved in abortion decision-making was a right to be left alone, a freedom from state interference. If that was true and poor women couldn't afford to have abortions, well, that wasn't the state's fault, that was poor women's fault. In 1976, the court held that even Title VII didn't reach pregnancy discrimination, and so it seems the idea of meaningful reproductive choice faded away. But nothing could be further from the truth. That idea reappeared in Congress, and it helped drive the push for the Pregnancy Discrimination Act of 1978. Surprisingly, that idea united women who disagreed fiercely about the right to abortion. I think it's easy to understand why feminists would embrace meaningful reproductive choice. It's harder to understand why anti-abortion women would, so I want to talk a little bit about that. Anti-abortion women came to the idea of meaningful reproductive choice because they framed their cause in part as an equality cause, arguing that abortion represented discrimination against the fetus. In practice, they argued that they were simply interpreting existing equal protection doctrine, which, as some of you might know, requires that a group have a visible and immutable trait, a history of discrimination, and political powerlessness. The problem, of course, was that fetuses didn't have a visible and immutable trait. They weren't visible at all, and any trait that defined them, such as residence in the womb, would change if a pregnancy wasn't terminated. What anti-abortion activists argued was that what truly mattered to equal protection analysis was vulnerability and dependence, and some of them were willing to acknowledge that those traits applied to other people, like the poor. While abortion opponents agreed that equality was the way to go, they disagreed strongly about what it meant, and in particular about who counted as a vulnerable and dependent person. Some relatively left-leaning abortion opponents identified women as a key group of vulnerable and dependent persons. And why, you ask, were they vulnerable and dependent? Some abortion opponents argued they were denied meaningful reproductive choice at work. If they faced discrimination at work, they had a choice between either terminating a pregnancy or losing a job, and as they argued, that was no choice at all. The most visible face of these arguments was Marjorie Mecklenburg, who would later become famous as an arch-conservative in the Reagan administration. In her early years, she was a home economics professor, the wife of a Planned Parenthood obstetrician, and a sort of bizarre proponent of choice. Mecklenburg argued, quote, that women are making choices about whether to give their child the right to life based on discrimination and economic conditions. If they feel pressured because of poverty, we can ask what kind of choice that really is. Mecklenburg and her allies then lobbied for a surprising range of laws, including amendments to the Social Security Act allowing women to claim unborn children as dependents, laws at the federal and state level banning discrimination on the basis of both marital status and pregnancy, and expansive welfare programs for indigent mothers and children. Of course, part of the idea was that if women didn't have economic pressures, they would have fewer abortions. And from Mecklenburg's standpoint, that was a great idea. She supported an amendment banning all abortions, even in some instances when the woman's life was at risk. But she went further, endorsing some idea of constitutional choice, admittedly one that had nothing to do with abortion, but an interesting one nonetheless. Many women, she argued, pressed by financial circumstances, have only the freedom to abort. But alternatives to abortion must be real if conscience and responsibility are to be more than rhetoric. This means that society must offer good health care, daycare facilities, maternity and paternity leave, and protection from discrimination in the workplace. Feminists, of course, hated Mecklenburg for lots of reasons, but they agreed with her in part about the idea of choice. Wendy Webster Williams, who had litigated many of the meaningful reproductive choice cases, agreed that the Pregnancy Discrimination Act was important not just because of what it meant about women's equality, but because of what Williams called, quote, the burden placed on the woman's choice to have a child. Key proponents of the PDA, Pregnancy Discrimination Act, that is, on either side of the abortion issue, agreed, describing it as a guarantee of reproductive liberty as well as of equality. So then the question is, what happened? Where did this idea of meaningful reproductive choice go? I think there were three problems. The first was that the anti-abortion movement in the early years didn't do as well as it would have liked, and its big win was the Hyde Amendment, which was a ban on publicly funded abortion. In that fight, anti-abortion activists had argued extensively that the right to abortion involved nothing more than freedom from state interference. And over time, it became clear that it was awkward for people to be making an argument that choice involved the means to effectuate a right in one context while denying it in the other. It became particularly awkward when every year in Congress, people on opposing sides of the abortion issue were fighting about the scope of exceptions to the Hyde Amendment, involving things like rape and incest. And more pressure was put on people like Mecklenburg, who had argued for meaningful reproductive choice. At the same time, to a greater extent than ever before, political party realignment and the mobilization of the new right and religious right left little room for the arguments about choice that some abortion opponents had made. It's important to notice how desperately poor and uninfluential in some ways the anti-abortion movement was in this period. The National Right to Life Committee, which was the richest and most influential organization at the time, was about $25,000 in debt at a time when Jerry Falwell's Moral Majority, which had formed barely a year before, had a $4 million operating budget. Many abortion opponents recognized that the way to political influence and financial stability lay with an alliance with social conservatives who agreed with them on abortion and didn't necessarily agree with them on welfare or labor policy. At the same time, the Republican Party took a position in favor of a fetal protective amendment to the Constitution, against public funding for abortion, and the Democratic Party for the first time came out in support of the Roe decision, at least calling it the law of the land. Not really a ringing endorsement, but better than a fetal protective constitutional amendment. And so again, for people like Mecklenburg, the choice was between a rock and a hard place, between political influence and principle. Mecklenburg chose political influence and became the face of policies like the squeal rule, which would require Planned Parenthood and other providers to notify parents if their children sought reproductive health services, of a policy of pushing abstinence education rather than contraception and the very alternatives to abortion that Mecklenburg had once championed as part of a social safety net for women and all Americans. Of course, Mecklenburg's earlier ideas didn't make sense anymore in a Republican agenda. While Mecklenburg joined some feminists in describing some forms of welfare as a right, Reagan and his allies described all welfare programs as a dangerous source of dependency. While Mecklenburg had argued for the expansion of protections against discrimination, Reagan and the right presented these as a dangerous form of special treatment or discrimination that took rights away from men. So I think the final thing, and maybe the most relevant thing for feminists, was that in the 70s and more in the 80s, feminists began mobilizing to develop a better explanation for abortion rights. Since the decision of Roe and the Legal Academy, even those who agreed with the idea that abortion should be legal thought that Roe could have been better reasoned. And many of these commentators, like Ruth Bader Ginsburg, argued that equality was a better rationale than privacy. This may well be true, but in arguing this, some of the transformative ideas about choice and privacy that had circulated in the 70s began to fade from view. So I too am not very good at talking about the future, because generally I find that no one cares when I talk about the future, because I have no special knowledge. To the extent I have any special knowledge, it's not in that domain. But I think there are a few ideas that come from this history. One is that the courts have been a problematic place to look for change in this area for a long time, and it's especially true now. The court's interpretations of the Pregnancy Discrimination Act and a case currently before the Supreme Court involve what are called pregnancy-blind policies. The idea is that if an employer's policy doesn't explicitly exclude or discriminate against pregnant women, it's okay, even if it, in effect, totally denies them any accommodation, and even if the employer chooses to give accommodation to other workers, such as those injured on the job. As you can imagine, very few pregnant women are quote-unquote injured on the job unless you happen to enjoy intimacy in unusual places. So, the surprising thing is that the federal courts have almost entirely or universally upheld pregnancy-blind policies as consistent with Title VII, notwithstanding the fact that women on either side of the abortion issue in the 70s would have been horrified by this, because it clearly created just the kind of burden on reproductive decision-making that women agreed was a problem. This history might also suggest that the legislatures, at least in the state and local level, are a more promising path. At the time, feminists made a great deal of progress in those arenas, and they have now too, promoting pregnant workers' fairness acts at the federal level, but with some success at the state and city level. I think most importantly, the story of the debates of the 70s shows something surprising about the potential of choice arguments. Choice arguments managed to bring together women with very different views about abortion and gender roles. These claims allowed legislators, at least temporarily, to understand the importance of both workplace equality and reproductive health care for poor women and women of color they so often ignored. The history I think I've described makes clear that choice arguments can be many things: limited, limiting, uniting, and constantly evolving. But they reminded me that the women who made those arguments were just the same, even those with whom I strongly disagreed. Whatever kind of woman you are, whether you're conservative or liberal, for or against abortion, you necessarily defy easy categorization. So, thanks.
Thank you so much, Mary. That was wonderful. It was really enjoyable for me, and I'm sure for all of us, to hear the two of you who are looking back at this thing that we did so long ago, give us that bigger, kind of higher view of what happened. Thank you very much. From that, we're gonna kind of move into the down and dirty. And that means we're going to talk about these same issues from the perspective of people who were kind of in the trenches. And one of those people is one of my best friends in the whole world. And I just realized I don't think I ever got to introduce her before in any kind of situation like this. Lisa Van Amberg and I went to St. Louis University Law School together. We graduated in 1975, and this summer before, a year before we graduated, Lisa and I and a couple other women in our class kind of looked at each other and said, maybe we won't apply for jobs. What do you think? Maybe we'll try to start an all-women's law firm. And so we did that. And we had some absolutely fabulous years together. Lisa went on to join a more traditional labor law firm, Schucott, Cook & Werner, where she worked with another one of our panelists, Sally Barker, doing both traditional labor law and employment law. Lisa's first trial as a lawyer was a class action against the Missouri Highway Department, and I'll let her tell you some of those stories. She served for many years as a trial court judge in the city of St. Louis. She currently serves on the Missouri Court of Appeals, having been appointed by Governor Jay Nixon in 2012, and she's got a special job there helping to move employment law in the right direction here in the state of Missouri. She's a fabulous person and a wonderful lawyer. Lisa.
Thank you, Mary Ann, my dear friend and former law partner and friend-to-be. We're growing old together. It's fun. It's fun. So down and dirty I'm supposed to get. Oh, boy. I can tell you that Mary Ann and I and our two other partners, Adrienne Anderson and Nancy Everett, in 1975 embodied the phrase, "where fools rush in." We hung out our shingle and went to work, Mary Ann and I, and initially Nancy, in the field of employment law under the newly enacted Title VII 1964 Civil Rights Act. When I say newly enacted, I mean it was about 10 years old. And the reason why we had that idea is because the Justice Department contributed to a clinical program at St. Louis University Law School in training lawyers to become what they called private attorneys general to enforce the 1964 Civil Rights Act. And the clinic that was funded at SLU was in the field of employment law, Title VII. And so, as it turns out, in St. Louis, I don't think there was not even a handful of lawyers, and they were mostly old guard civil libertarians doing Title VII work, not very many. I believe that we had more knowledge coming out of law school than they did about Title VII, but we had absolutely no clue how to litigate. And our first trials were in the United States District Court for the Eastern District, Missouri, in the federal court. And in the federal court, there was a bank of silver-haired white judges who considered this new law to be the bane of their existence. I think one of them said to me, or you, when are you going to start practicing real law? Which was a backhanded compliment because he kind of liked us, but he didn't like the kind of law that we practiced. To say that they were hostile to the Civil Rights Act is to understate it. They were extremely hostile, and we soon realized that we had tackled a huge issue of just trying to educate these judges. Now, mind you, back then, there was a decision made in Congress to take out the jury trial from 1964 Civil Rights Act because it was assumed that Southern juries would be hostile to these cases. And so they had them be decided by judges, and in certain parts of the country, the judges were more receptive than others. In the Midwest, we did not experience a receptive bench to the Civil Rights Act of 1964. And so we suffered many losses and bruises there in the federal court in the early days. My first break came, as Mary Ann said, with a class action suit that we filed against the Missouri Highway and Transportation Department. And we had a pretrial conference with United States District Court judge from the western side of the state by the name of Scott O. Wright. And Judge Wright was, unbeknownst to me, was a Roosevelt Democrat feminist white guy. I mean, he said, why don't y'all have a jury trial? Why don't y'all have a jury trial on this? And he told us that, I think it was about 4 weeks before trial. And I had never had a jury trial. But it turned out to be the break that we needed. And what was so interesting was that he was schooling us in the trial. You know, if he didn't think we asked a question quite as well as he would have jumped in with his own question. Most famous, which I remember, the highway department said they were so open about it. We can't hire women because we don't have restrooms on the highways. And Judge Wright said, and this is how he talks, well now, has the highway department ever heard of porta potties? And I turned to my co-counsel, Karen Plax, from the other side of the state, and I said, I think we could win this case. A novel idea of winning this case. But it soon became our effort to learn on just a micro scale how to educate the judges and the jurors about equal rights in the workplace. And for us, in cases like this, it wasn't as hard as it is today to educate judges and jurors about comparable worth issues, for example. That's extremely complex. But back then, it was pretty, it was interesting how we did it. I look back on that, and I did sort of subconsciously choose the named plaintiffs who were single women, who were single support of their families, because we didn't want to have to deal with this issue of you don't need this job. And believe me, we heard that quite often. You don't need this job. So the named plaintiffs were all rural Missouri women who were farm women who did need these jobs. They were supplemental to their farm income, and they these jobs would push them above the poverty level. These were entry-level jobs in the highway department, but we also managed to get photographs of them on heavy machinery. We showed the jurors these women driving graders, bulldozers, to be able to visualize these women in the job. This is the kind of fundamental stuff we were working on back then. And to talk about the judiciary, following up on some remarks about the judiciary, that I think that the progress was in Title VII for women was made after the Anita Hill hearings, when it was decided, well, we do need jury trials in these cases because it was impossible for those guys to understand sex harassment, as we all learned, and what women experience in the workplace in that phenomenon. And once we did obtain jury trials, then we began, at least in our courts, to have some success, and we learned jury trial skills as we went. And now, after 27 years of practicing law, after I left our firm, I joined Schucott, Cook & Werner. my partner Sally Barker is here, and Loretta Haggard is here from Schuchat, union side labor law firm. And I continue to do litigation in the field of First Amendment for public school teachers, and had some fascinating cases in that arena. But mostly, doing arbitration work and working with unions, and it was just such a wonderful experience for me. After doing that, I decided that judiciary was important. The judiciary is extremely important in outcomes for women in the workplace and for all people in the workplace, as well as the arbitration field. But as it turns out now, at least in this part of the country, the parallel state laws are where employment lawyers such as Marianne are having success, because Marianne has become an expert litigator in jury trials, and she has been able to educate juries about these issues and been able to put some economic pressure on employers in prevailing on juries to rule in favor of her clients. And I think that the state courts are becoming an important arena for civil rights and employment issues all over the country. So that is why, that's one reason I wanted to be on the judiciary, and I became a trial judge in 1993 in the city of St. Louis, and then I have moved up to the Missouri Court of Appeals. I think that the Missouri Court of Appeals does some very important work, and I'm very happy to be able to sit on that court. But the judiciary does matter, at least in the state courts, when you're litigating in the state courts. And I'm just going to put in a plug for the Missouri Nonpartisan Court Plan, and many of these nonpartisan merit selection court plans that started here in Missouri are under attack all over the nation, because the oligarchy has figured out we need to control these people on the bench. And it is the judiciary has now evolved to be one of the backstops for working people who don't get help in the legislature and can't get help in the executive branch. And so in Missouri, at least every year almost, we face attacks on the Missouri Nonpartisan Court Plan. So I want to raise your awareness about, although the judiciary can't solve all of the problems we want to solve, it's now become a very important arena for this work. Thank you.
So the final member of our panel is Sally Barker, who for many, many years was Lisa's law partner at Schuchat, Cook & Werner. But Sally has been an important part of the women's movement in St. Louis for many, many years in another arena, and that is the political arena. Sally is the founder of the Women's Political Caucus here in St. Louis, founded that organization in the 1970s. She has played a critical role in the campaign of all the important women who've been elected to office in Missouri. Harriet Woods, Betty Van Susan Block, Jean Carnahan, Robin Carnahan, Margaret Donnelly, Senator Claire McCaskill. Sally has been involved in all those important campaigns. So she's talking here as a lawyer, but she's played a much bigger role for us here in the state of Missouri. Sally does labor law. She does employment discrimination law as well. And just following up on Lisa's plug for the importance of the state courts these days, Sally represented the prevailing public employee unions in the Missouri Supreme Court decision that determined that public employees in Missouri have a constitutional right under the Missouri Constitution to engage in collective bargaining. It's hard to imagine a more important decision than that one. Sally?
Well, thank Thank you, Mary Ann. Let me correct. I am a co-founder of the Women's Political Caucus, not the founder, but okay. My involvement in the women's movement did precede my involvement in the labor movement by quite a number of years. In preparation for this talk, I thought about when did I first become a feminist, even though I didn't know the word. It was my junior year in high school, and for some reason a teacher asked us to say what we envisioned ourselves doing in 10 years, and it came my turn, and I said, I will be practicing law. And the whole class laughed, including the teacher. So I have my 50th high school reunion coming up. I did not come from an environment where I knew unions, didn't know anything about them, don't think I knew any members of unions. But I went to law school and I started practicing law at a large firm. And I thought I wanted to just be a litigator and that I would be able to litigate sex discrimination cases on behalf of women. That showed how naive I was because corporate law firms don't represent plaintiffs in sex discrimination suits. But I was assigned some management side labor law cases while at that firm, got very good training, and I found the issues interesting, but I found my underdog heart sympathized more with the other side. So I was fortunate enough to have an opportunity to go to my present firm, which is Shuka, Cook & Warner, where we do union side labor law and some employment discrimination as well. And interestingly, I have significantly more women partners, always have at that firm, including Lisa. And I also found a more family-friendly environment in which to work. I joined that firm in 1982, and I just have one more observation about contrast between the corporate firm and the labor firm. I always or very often felt when I was introduced to a corporate client, I could just hear them say, and some said out loud, "Why did they give me the woman?" I went to start representing labor unions. Most of the leaders and officials in the beginning of my career were men. I never got that feeling. I don't know how to explain that, but the receptiveness to myself, to Lisa, and our other women colleagues was much better. Now, over the period, I decided I could talk about all the problems with unions in the history of the women's movement, but I'm not going to do that. I prefer to talk about the progress that I have seen over the 30-plus years of having the privilege of working with labor unions on these issues. And I am going to also venture a little bit into what I see about the union's role in the future with respect to women. In these 30-plus years, there has been significant development of legal rights for women in the workplace. With a couple of exceptions, unions were not on the cutting edge of those development of those rights. It took courageous women and their courageous lawyers, two of whom are on this panel, to take these cases under Title VII and to develop the legal rights that a lot of us have enjoyed. No statute is self-enforcing or even self-defining, and it took a lot of those litigation victories to advance those issues. There is one notable exception, and I learned this morning probably why there is this exception about the union on the cutting edge. And that is that the UAW won a case in 1991 called UAW versus Johnson Controls, which puts some meat on the Pregnancy Discrimination Act. That case involved a company that decided to paternalistically refuse to assign any women of childbearing age, not pregnant women, any women of childbearing age, to any job that involved certain chemicals, which of course were the higher paying jobs. UAW successfully challenged that rule as a form of sex discrimination. But it is true that structurally unions were not on the cutting edge of the definition of these legal rights. And there's, I think, a reason for that. Unions are democracies. They're imperfect democracies, but they are controlled by their members and more directly by the leaders those members elect. So when we're going back to the 70s and 80s, women were not as much as did not constitute a majority of members of most of unions, with some exceptions. And so it's really not surprising that they were not pushed to do the pioneer work in women's rights. But I do believe that that has changed, because more women, led by all these wonderful women we heard about this morning, have joined the organized workplace and have become activists and leaders in that. In contrast to litigation, unions' principal tools are negotiation, arbitration, and political activity. Those tools may not be as effective in defining legal rights, but they are cheaper, they're faster, and they may have a much broader effect ultimately. So I'm going to talk about some of those enforcement tools that unions used over the past 3 decades. Negotiation of labor unions, of collective bargaining agreements. There really potentially is no faster way to improve a working place than to negotiate a better labor agreement. Now that depends on who's doing the negotiation on both sides of the table. When I first started doing this kind of law, I did not see collective bargaining agreements with anti-discrimination clauses in them, maybe some, but not all. Today, I don't know a single union contract that does not have an anti-discrimination clause covering all forms of protected classes and discrimination. And I have seen unions in some places include categories of discrimination that are not legally required, like sexual orientation. So those discrimination clauses are not self-enforcing, but they did give the union a tool with which to raise the issue of sex discrimination in the workplace. The dispute resolution mechanism under a labor agreement is grievance arbitration almost universally. And early in my career of doing this, it was fairly typical if a woman came to a shop steward and said, I think I didn't get this job because I'm a woman. The best answer she could expect is, here's the address of the EEOC, go file a complaint. That doesn't happen, at least as much anymore. I think unions are much more sensitive to the fact that all members of the bargaining unit have to be represented. And if there is a claim of sex discrimination on a part of a bargaining unit member, grievance arbitration can be an effective tool in pursuing that situation. I do not mean the kind of arbitration which includes arbitration of statutory rights. Don't worry, Mary Ann. For those of you who don't know this, management has tried to control Title VII litigation by getting unions to include in their grievance arbitration provisions not only issues concerning the violation of the labor agreement, but also statutory issues, and get unions to waive their members' rights to go to court. If they're a client of my law firm, they know never to agree to those clauses. And I think the majority of unions know that and try to avoid them. But because grievance arbitration can be much faster and cheaper, if a woman is denied a job because the supervisor doesn't think a woman can do it, and the union pursues that, that issue can be resolved in 6 months, if successful. So it is that a lot of these legal rights are defined by litigation, but can be enforced effectively by unions through grievance arbitration. Another issue that has changed in this regard is the issue of sexual harassment. It certainly was pervasive when I started doing this. We may not have known exactly what to call it because the law had not been as defined, and very rarely was anything done about it. But that is changing. If an employer, for example, if a woman complains to the employer about sexual harassment of a supervisor and the employer ignores it, the union can file a grievance against the employer for failing to resolve that problem because of the anti-discrimination clause in the collective bargaining agreement. These cases are not always easy. Sometimes they involve complaints of sexual harassment between bargaining unit members. And about 20 years ago, one of my male partners came down the hall and said, "Sally, I have a case I think you ought to handle." That should have been a warning, because it turned out to be the absolute nightmare sexual harassment case for a union. It was a company that did not have a sexual harassment rule, did not have a sexual harassment complaint procedure, no training, nothing. And a 30-year employee, a brand new woman, the first woman in the bargaining unit, was assigned to work with a 30-year employee with a clean work record. And one day, the woman employee came to the HR and said, "I have had to endure sexual jokes, sexual comments. The guy has Playboy magazines in his truck, etc." What was the company's response? Immediately, they called their attorney. They said, "Get rid of that guy." Now, so initially, the union was saying, "We've got to go to arbitration on behalf of this 30-year employee with a good work record." Well, it's a tricky situation, but our advice was you first need to interview the woman, because she's represented by the union also, and you need to make a determination as to who is telling the truth in this situation. As it turned out, with our help, the union concluded that the woman was telling the truth. This was going on. But unions also believe in the concept of progressive discipline. We ended up arbitrating that case, but telling the terminated male employee, we're not going to cross-examine the woman when she testifies because we believe what she said. The only thing we're going to argue is that the company is really at fault because the company had no rules on this, no training, no complaint procedure, and he ought to get some second chance, and the arbitrator agreed, put him back with a healthy suspension and a transfer away from that woman. So, you know, it can be tricky, but unions do have a duty to represent everyone in the bargaining unit, and if done fairly, it can fulfill that obligation. I'll just talk for a second about the future, which is that I think unions' impact is going to be much broader in the future because there are many unions now who are majority women, and most of those unions represent very low-paid workers who are exploited not only in terms of wages, but working conditions. And those women, litigation is not the easiest answer. They need relief sooner, quicker, and these unions, one of the leaders of one of these unions is here today, Nancy Cross of SEIU. Are getting very involved in organizing healthcare workers, including in Missouri, home healthcare workers, hotel workers, fast food workers. That's what the SEIU is doing. And for most of those women, they don't even know what the glass ceiling is because they're so in the basement of the workplace that it really isn't an issue for them. They need relief on better wages and better working conditions. And I am very encouraged about the future of unions to be able to have a broad and positive effect for those women. Thank you.
Thank you very much, Sally. Now we'd love to hear from you all. Questions, comments, and in fact, we'd be interested in hearing the panel talk to each other about some of these issues as well. So anybody out there got anything you want to add? Any question you want to ask? Muriel? Mary Jean Muriel's got her hand up.
How big is the threat about the movements, the conservative movements, to impeach judges for their decisions and to put a lot of money into electing conservative judges? Is this a serious problem?
Did everybody hear Muriel, or would you like the question again? Would you ask it again, Muriel?
How serious is the problem? Will you repeat my question?
All right, Muriel wants to know how serious is the threat of conservative organizations, conservative movements to impeach judges for decisions they don't like. Maybe Lisa would speak to that first.
Well, I'm not aware of any viable effort with respect to federal judges because, you know how the impeachment process has to go through Congress and in the federal system. Impeachment isn't so much the issue in the state courts as is judicial selection. The way in which judges are selected is a target of the right conservative groups funded by the Koch brothers and others. There has been a repeated effort in Missouri, which initiated in the 1930s, I think, what's called the nonpartisan court plan, whereby appellate judges and judges in urban areas would be selected by a merit selection commission to come up with the 3 nominees to the governor, who would select one from those 3. And that Missouri plan, it's called, has been a model for judicial selection all over the country. Most states have it in some way, shape, or form. The effort in the last 10 years, though, from the right wing has been to alter that method of selection to either have the Senate of the state approve judges, which we all know how fast that works in the federal government, or have the governor in power maybe appoint, or even have elections such as you do in Texas. I don't know if you know, Illinois and Texas, if you all see commercials on your television for electing judges. And so that has shown up in the last 5 years in Missouri every year. It was on the ballot here a year ago. The voters defeated it, but it keeps getting introduced into our, onto the floor. So judicial selection is the battleground. Not so much impeachment, although, I suppose that's not going to be as successful. But they have made a lot of progress in impinging on judicial selection, and this is where I say, I agree with Sally, and I think, Marianne and I have talked about this as well, that a lot of the action is not in the courts anymore in employment rights. It is in other arenas too, but when it gets to the judges, and we remember from the early days how much influence those judges had on the outcomes, when it gets to the judges, if the Koch brothers are trying to alter judicial selection, we need to be worried about that.
Yep. Could I just add one thing to that,
Yes.
which Lisa may not be able to add anymore because she's now a nonpartisan
She's telling me to
judge.
shut up in a
No,
nice
no,
way. No.
No, all I'm adding for those of you is that beyond preserving the nonpartisan court plan, you also have to preserve a Democratic governor because
Yeah.
if you don't know, and I realize not everybody's from Missouri, the way it works is a commission sorts through applications and comes up with a panel of 3, and then the governor picks from the 3. So if we have a Republican governor in the future, everything in Missouri employment law may change rather rapidly.
Yeah. And by the way, I'm on the ballot in December, so I shouldn't even be having this conversation. I thought that's what Sally was going to warn me about.
Yeah, I want to talk a little bit about that because I've been through this, we're looking back. So I've practiced this kind of law for 37 years now. And all my early years were in federal court. It was exactly like Lisa described. It was terrible, okay? Once even when we got the right to a jury trial, then the judges had a new tactic, which are called motions for summary judgment. And what would happen is we'd never see a jury because the defense lawyer would file a motion to throw our case out and say there was no way, no matter how much we proved, given the facts of the case, that we could prevail, and we were out on summary judgment. And I don't know how much you all know about this, but this is a major problem in federal court. They toss the vast majority of employment discrimination cases get tossed on this summary judgment stuff. So, we had this absolutely amazing period in the history of the state of Missouri where we had progressive Democratic governors for over 20 years. There was a 4-year period in there where we had a Republican again, but we had Bob Holden, Mel Carnahan, and now Jay Nixon, all interestingly enough from rural Missouri, but Democrats and progressives all. As a result, we have an amazingly progressive bench in Missouri now. And employment lawyers will tell you that Missouri has better law protecting employees than almost any other state in the country now as a result. And we read about ourselves in the New York Times, and we know how bad we look on a lot of things. But let me tell you, in this area, Missouri is way up there in terms of those legal protections. Now, having said this, I agree fully with Lisa and Sally that the courts are not where we're going to make our greatest progress in the future. We can talk later about why. But the critical importance of having political underpinnings and the importance of these campaigns for so many reasons. We cannot underestimate the importance of that to all the things we've been talking about here. So much of the stalled progress over the last 30 years has to do with what's happened in politics in the United States, no question.
Shelley?
We have one over here, and then we'll get to over here.
I just want to take you back. Can you hear me? Take you back just a little bit to the early 1970s. I was president of San Francisco Now, and we had 3 cases brought before us. There were no women lawyers, judges, or anything else, and 2 we won by protest and 1 privately. And I'll tell you, the first one was that women who were working at Super Shuttle, you know, the transportation, they had to wear very short mini skirts up to here, whereas the men, of course, had their pants, and it was very windy and cold, and there was all kinds of sexual harassment going on, so we had to protest on that one. The other was the Bank of America. 6 women brought cases where they had to train the men to be the executives that they should have been because they had worked there for many, many years before, and these young men suddenly got the jobs. The third one, which was the one that touched my heart the most, was that the tellers, women who worked at Sumitomo Bank, it was a bank in California which originated in Japan but had a California contract, brought us a case that all of the women who worked there, the tellers and so forth, were getting half the salary of the men, and there were no managers. At that time, I was the private tutor of the Sumitomo Bank president's children. And so it was, and I had dinner at his home many times. I speak Japanese and all that. And so it was kind of a shock when I told him that he was going to be called into court. He had no idea of what now was or anything, and it was very difficult for me. But I finally convinced him not only to raise up the salaries and follow the California contract, but to also have the first and only woman on the board of directors of the bank, which he also agreed to. And I have to tell you, the one that he chose was Shirley Temple Black. But nevertheless, it was good.
Thank you. Thank you.
Mary Jean, we had a question over here in the
That was Shelley Fernandez. That's who we got over
orange blouse in the front row, Mary Jean.
here. All right. All right. Say your name.
Mary Bennett of Chicago, Illinois, member of CLU and now foremost, and have been active in these organizations for years. But I can recall reading along, I would say about 20 years ago, you know, the rise of the conservative movement, which is a source of a lot of the problems that women face today, whether it be the formation of right-wing think tanks, you know, like the American Enterprise Institute, the Heritage Foundation, and other social conservatives who put a lot of money in changing the terms of the debate to begin with. You know, they have, you know, their positions were presented in newspaper articles and on television and radio, you know, to promote certain ideas. In addition to that, you had somebody like Lewis Powell, who was later, you know, now, you know, selected for the Supreme Court, who was quite blatant, you know, in saying that business interests had to find a way to gather a foothold in the political environment. They saw organized labor as having too much political power. So fast forward to now, and this is what we're seeing. So in order to change the legal environment, we've got to change the political environment.
Yep.
Thank you. Thank you.
We have a couple more. One way in the back, and this
This woman?
young woman here.
And then you're next.
Yes.
Please say your name.
Thank you. My name is Beth Barton, and I'm a tradeswoman and the president of Missouri Women in Trades, which is a nonprofit. Thank you. My question for the panel is, I understand what you're saying, that when we have litigation, it creates laws and that changes culture. As a person in an industry that is far less than 3% female, would you recommend that tactic for tradeswomen? Because as a tradeswoman, if you have an issue and you want to report that issue to the National Labor Relations Board or OFCCP, if your contractor applies for that, you have to say your name. So do you recommend that as a tactic?
Everybody's looking at me.
Well, I'm going to tell you what I say to people who come to me and ask me that question. I say lawsuits are the last resort in the kind of situation you're describing. And the reason I say that is that, for instance, as a tradeswoman, for instance, you have the grievance arbitration process. And that is faster and cheaper, as Sally said, but also it's more acceptable in the realm that you work in than going and filing what we used to call a federal lawsuit. So I think litigation is the last resort, but sometimes you got to go to the last resort. It depends on where you are and what the problem is. Because the other thing we all know is that retaliation is real too, and so is being shunned by the people you work with, and life can get worse. So I think you want to try everything else first. I think you want to engage in every other form of trying to solve the problem first, but if it doesn't work, give us a call.
I would suggest, if you work in a unionized setting, that you need to go to your union leadership. I know that's not easy. And unions do have the duty of fair representation. And whether the leadership sympathizes or will be concerned about the duty of fair representation, at least my clients, and we represent quite a few construction unions, they bring these issues to us. They know that they need to be addressed. They often want us to advise them. And we certainly don't advise them to ignore it. Now, yeah, and I have seen some construction union leaders who I wouldn't call the greatest feminists in the world, but go down and talk at a workplace and talk about union solidarity, and that if he heard any more about the treatment of the woman member he had heard about, they were going to have to answer to him. Now, will they all do that? No, but that's what a union is for, and if they don't do the right thing, there are remedies for that as well.
The other thing that I've experienced is that in every workplace, women who have problems have a few colleagues, coworkers, brothers who understand what you're going through. And involving those people, asking for their support, perhaps getting them to go with you to see those union leaders is another really good tactic.
Okay. Would you please say your name?
Hi everyone, my name is Adama Wilshire. I'm a third-year law student. And I'm hoping to practice labor and employment law in the future. But if we accept the fact that the courtroom is no longer going to be the place where we can resolve Title VII cases or cases related to pregnancy situations, what becomes the role of the attorney? What should be our new strategy in the future? And I think this is something that even the historians on the panel might be able to give us some insight into based on the research that they've done, I'm hoping. So if you can, give us a sense of what we should be working towards as law students, because now we clearly need a new strategy. So,
Great question.
I mean, I don't think, a lot of historians are correcting, I think, an overemphasis on the courts and on litigation. So at least I don't want to be understood as saying that litigation doesn't work. I think it's better understood And I think a bunch of us have said this sort of as one tool among many that you use under certain circumstances and for certain reasons. And it's still very valuable in that setting. But I think there was a narrative early on about sort of you can win in the courts and social change follows immediately that both downplayed other strategies for change that lawyers can use too. I mean, it's not like if you're a lawyer, you're precluded from direct action or political lobbying or other, I mean, a lot of the women here today can tell you that that isn't true. And historically, it obviously wasn't true either. So I think the idea is if you're in law school to put, at least what I tell my own students is to sort of put litigation in context, not to devalue it, but to understand it as sort of part of a more holistic strategy.
And part of the reason that we say that is because the tool of class actions has been unplugged by the United States Supreme Court. When I was talking about my highway case, what made that such a strong case was it was a class action. I represented women all over the state of Missouri. Now, it's very difficult to do. So, as we've been talking about, there is litigation for social change. There's litigation to solve individual problems. With respect to individual problems, it's just not cost effective.
I also don't want to give too negative a picture here. Let me say this, and I think it's really important for me to say this because I know you're not the only law student in the room. I love what I do. It is extraordinarily satisfying. It's extraordinarily important to me to be able to do it. I think I've made a huge difference in the individual lives of many people, including many women. I also believe I've made an impact on some workplaces. But all I'm really saying, and in fact my daughter does the same kind of work I do in Chicago, so you know, let me just say, it's great work, it's important work, it's work that if it's what you want to do it. It's great stuff. All I'm trying to say is I went into the law in 1975 to be a social change agent, and I don't know that the law is, in the sense that it was then, the kind of agency for social change that it was for that period of time for my generation of young lawyers.
Just one footnote to that. Being a lawyer is not synonymous with being a litigator. I mean, I agree, and Mary Ann does fabulous work as a litigator. But one of the things that we do as attorneys for unions is training. And this sort of may address the trade issue as well. For almost all our clients, we have given seminar or workshops on sexual harassment and other discrimination issues. So there is more to law than the courtroom, although it is a very important place.
You know, Pam Ross asked me to ask this question. Maybe some of you would stand up and show us. How many of you here are members of labor unions, work with labor unions? You're here because of your direct connection with labor unions. Would you stand up and let us see? Wow.
Excellent.
Yeah, and family members I see also. Thank you for coming. It means a lot to us who were in this business. Mary Jean?
Okay. Well, first of all, I want to thank the panel very much for, well, I guess you're going to do that. I shouldn't do that.
Do it.
I just want to say that during the break we have beverages outside and we are going to take a little break. But Mary Ann, you may want to, thank you very much. The panel was extraordinary. And Mary Ann, you might want to close it down.
Thank you very much.